I'm going to take a little bit of a different angle. My co-panelists have given me a very good introduction. I'm not going to give the club's view on piracy. I'm going to give the club's view on the use of armed guards, or the general club position on the use of armed guards and the regulatory and the insurance aspects in terms of the decision to use armed guards and what you need to do in order to maintain your insurance cover once you've made that decision. I think that my co-panelists did this very well in terms of giving us the history and the trends, and so I'm just going to go a little bit past this because basically it's all of this that has brought us to the decision to consider the use of armed guards. Okay. The use of armed guards. First, I guess the first thing we should begin with is that the presence of guards, whether armed or unarmed, on board the vessel does not in and of itself prejudice P&I cover. Certain risks, though, may fall outside the cover if minimum standards aren't met in terms of the contract with the private maritime security company. Now, BIMCO, it was a joint industry project which led to the issuance of BIMCO GuardCon, which ensures minimum standards, and that sort of streamlined a lot of this. But still, this doesn't take away from all of the considerations that went into the implementation of BIMCO GuardCon and all of the aspects that the ship owner needs to take into consideration when deciding to use armed guards and choosing the proper company. Essentially, you have to conduct a thorough voyage-specific risk assessment, and that includes looking at the type of vessel, the type of operation, where you are, the specific regional threats in terms of what was discussed earlier between East, West Africa. You also have to exercise due diligence in choosing a PMSC. While BIMCO GuardCon, again, does set minimum standards, it doesn't replace the requirement to exercise due diligence when choosing a company. And then again, despite the fact that there are standardized contracts, you still need to leave enough time for the security contract to be vetted by all of your insurers, and also to look at all of the individual aspects of the contract to make sure that you're complying with all regulations. Okay. Okay, the use of armed guards is one aspect of possible measures in addition to a multitude of protectional steps that need to be taken. So basically what I'm trying to do here is put together all the various aspects to give you a guidance in terms of the steps that you need to take. First, consult with your flag state authority. Second, make sure that you do and you conduct a thorough analysis of implementation of best management practices. Look at region-specific guidelines. Ensure compliance with SOLAS. There are issues in terms of additional people on board and additional equipment on board that need to be taken into account. You still should consult a lawyer to assist with the contract and to assess potential liabilities based on the voyage-specific risk assessment. You should look at IMO guidance on the risk of privately contracted armed security personnel. You should also advise your charter and your cargo interests because there's other contractual obligations. If you're going to take a different route for safety purposes, in terms as a result of your risk analysis, then you need to let your charter know so that you can avoid any possible allegations of unjustified deviation. Finally, vet your contract with all your insurers. In terms of flag state considerations, this is the #1 priority. It's a prerequisite to P&I cover. You have to find out from your flag state, do they even allow armed guards on board the vessel? What are the requirements for licensing of carrying weapons on board? Whether it has rules of engagement or rules of force, and you need to provide your P&I club with the flag state's written response. Of course, due to the developments in the high-risk areas, many flag states have now pre-approved lists of armed guard companies. Oh, back. Okay. Compliance with BMP. Armed guards are not a substitute for following BMP4, so you still need to have proper crew training, contingency planning. Owners should ensure that the PMSC is trained and familiar with BMP4. Owners should coordinate training between the master, the crew, and the team. Failure to comply with BMP4 can actually have very serious consequences. There are some aspects of noncompliance that could prejudice your P&I cover, and if you're found later, at a later stage, to have been non-compliant with certain measures of BMP4, you could have a situation on your hands where parties that are of interest to the voyage, such as cargo, that may contribute, let's say, to GA, because ransom actually does constitute a GA sacrifice. They could possibly avoid contributing. So it undermines the efforts to obtain contribution from cargo towards ransom or general average. The weapons to be used by the company. Now, this is another aspect that could impact on your P&I cover. There is no right of recovery from the association in the event that liabilities arise or are caused by mines, torpedoes, bombs, rockets, shells, explosives, or similar weapons of war. What are similar weapons of war? Well, they have to be something more than just your conventional weapons. They would have to be close to what the actual list is there. So you need to request the security company to specify precisely what weapons will be brought on the vessel. And if you don't address this issue in advance, you could again prejudice your P&I cover. So it is ultimately the owner's obligation to make sure that the weapons are carried on board, are licensed. Failure can subject the master and the crew to civil and criminal penalties. And those penalties or those fines would likely not be covered by your P&I cover. You need to ensure that permits are obtained from the port of embarkation of guards, the transit, anchorage, mooring, port of disembarkation, national laws of the country where the PSC is based, flag and port state restrictions and licensing requirements must also be met. And although a lot of these things are dealt with in GuardCon, it's still something that you have to make sure that you understand, you appreciate, and that you comply with. And the PMSC must also evidence all the licensing compliance as dictated by the contract. Insurance cover. So we're talking about all this time about the vessel's insurance cover. Well, what about the security company's insurance cover? This has been a topic of some debate. You need to request the security company's insurance cover. There are industry minimum standards in terms of insurance cover. The company should have third-party liability, professional liability, maritime employer's liability or workers' compensation. They should also have a personal accident policy for the guards on board. The general industry standard is minimum $5 million for the main three aspects of insurance. GuardCon also provides for that level of insurance. But even if you're not using GuardCon, the club would still require that you meet that industry standard. There are a number of contractual issues that were a huge debate, of course, before GuardCon came in. And I think that this was a big achievement. Assume liabilities. IG clubs require terms no less favorable to the ship owner than knock for knock, which means that each party is responsible for their own damages. This is an important aspect because while initially the terms for knock were taken as let's say for granted that, well, you have TOCON and they have knock for knock, so why not have, private security guards with arms on board and let's have knock for knock. It makes sense. It doesn't, there has to be a more finely balanced situation here because the use of weapons on board creates an inherent higher risk of damage, of death, of injury. So it's not really the same thing as a TOCON. So what GuardCon has done, and what, even if you're not using GuardCon, you should ensure, is that there's a fine balance. In other words, indemnity provisions, you have to make sure that they don't act as a waiver, and you have to make sure that you specifically actually list and maintain and preserve the right to limit your liability. But ultimately, you have to make sure that in terms of knock for knock, for example, in GuardCon, if there's an accidental discharge of a weapon and there's the third-party liability injury or damage, well, does it really, those kinds of things, that kind of liability should better fall on the people that are trained to handle that. The next big issue, or one of the biggest topics in terms of the negotiation of GuardCon and contracts related to PMCs in general, is who's in charge. Who ultimately authorizes the use of force on a vessel? We all know that the master is responsible for the overall safety of the vessel, but he may not really be prepared for combat decisions. And ultimately, the responsibility should not be on him to make the decision whether to open fire in a situation. So you have to make sure that the contract includes clear and concise rules on the use of force and on the roles that each party plays. SOLAS and ISPS compliance must be ensured. I think that another big accomplishment, I think, of GuardCon is that I think it managed to meet that balance. It recognizes that the master is ultimately responsible for the safety of the ship. It gives him a right to ask for a ceasefire, but it doesn't override the ultimate right of the guards to use the necessary or appropriate force in a situation of self-defense. And I think that's very key. Criteria for selecting a security company, as I said, this is still a very big issue, and it's very important that you follow all the steps to choose the right company. You should look at the structure, the financial position, the extent of insurance cover, the experience. Now we have the development of ISO accreditation, background information, their experience, their written procedures, their understanding of regulation, their understanding of the area and the region. You have the right to ask for and look at criminal background checks, employment history, their particular background in military or law enforcement, medical checks, mental fitness records. I mean, these people they're going to be carrying guns. They're going to be carrying serious weapons. Training. Look at how they train. Look at what they do. Look at their procedures. Okay, so then when we're making the decision, let's go back. This whole process, if you follow all the industry guidelines, should take you to the right choice, okay? You don't want to end up with something like this, because this could possibly violate your P&I cover. Overkill. You also don't want to end up with something like this, right? So, because you might be found unseaworthy. So, following the guidelines should get you to the balanced, the just right position. Ultimately, the use of armed guards is an operational one after doing a thorough voyage-specific risk assessment. Obviously, with the trends and the developments in the various high-risk areas, there has been some shift, let's say, in the industry of previous opposition to a more neutral standpoint in the use of armed guards. And there's a lot of things to be said for the use of armed guards, obviously. It's a complementary solution to multinational naval coalitions. It does create a harder target for pirates, that was pointed out. They tend to go look for a softer target. There's well-known and evidenced benefit of using PSCs, and the ship owners do have the right to obtain all options to deter piracy attacks and defend their crews and the vessel. It's a good preventative measure to avoid high costs associated with post-hijacking efforts. Many armed guards are highly trained former military personnel, and of course, as far as I know, and as far as my research indicated this past week, still to date, no vessel with armed guards has ever actually been hijacked. That says a lot. Of course, there is still an inherent danger with putting weapons on the ship. Some of the downsides, or let's say the problematic areas of armed guards, is that it's still at this time, there's still an inability at present time to consistently ensure qualities of standards of PSCs. There may not be enough qualified guards to go around. It's also to date unregulated in terms of an industry. It's still not, we can't say that it's not endorsed, maybe neutral, but it's not endorsed by the industry. There's an uncertainty, like I discussed before, about the rules on the use of force. Even when you have the rules of force clearly set out within the contract, it's not always that easy to implement them. And there's potential criminal liability issues. It could escalate violence and prompt pirates to be more aggressive in future attacks. And then there's an issue of the various countries' laws that apply in terms of possessing and licensing of weapons. I don't think it would be appropriate, it wouldn't be appropriate if I didn't also talk about the use of armed guards in the West and with the latest developments in West Africa, because it's a little bit more complicated. Local legislation of the various countries in the region may conflict or prohibit the use of private guards inside the territorial waters of the coastal states. That would sometimes actually make it a lot more logistically, a lot more difficult to use private security guards, sometimes impossible. Local or government forces should only be used if legitimate and trusted, and the vessel's flag state will usually require the same type of vetting and minimum requirements as far as PMSCs are concerned. And that may not be possible to be met. Clubs will also require the same standards for the use of armed guards to be met. I would just like to point out actually right now that there are efforts in progress to create a version of GuardCon that would be tailored to the specific region of West Africa. All industry guidelines for the specific region should be strictly adhered to, and the usual voyage-specific risk assessment conducted. And ultimately, the use of armed guards by way of local government police or military personnel should only be used if the risk assessment warrants it, and it is a requirement, and then only as a supplement to ship protection measures of BMP4. And that's about it. Thank you.